Welcome, everybody. Feel free to come a bit closer, but we're not that many in the room. And later for the Q&A and for the debate, it could be practical or cozier, maybe. But first of all, I just want to welcome you all to this session and briefly introduce myself. My name is Olivier Hoedeman, and I'm the coordinator of Corporate Europe Observatory. Also abbreviation CEO. We're a research and campaign group. We're focused fully on the problem of excessive industry lobbying influence in EU decision making. And I will moderate this panel. The panel is hosted by our allies from EDRI, and they organized this panel on behalf of the Rules to Protect network. So before turning to the panelists, I'll just very briefly introduce the Rules to Protect network and also make some introductory remarks to set the scene, and then introduce the key questions for this session. So the Rules to Protect network is a network of trade unions and civil society groups set up about 1.5 years ago. And it was created to push back against what Politico earlier this week referred to as the EU's deregulation crusade. So the watering down of social, environmental, digital and human rights protections that started in December 2024 when Ursula von der Leyen entered office for her second term. So the Rules to Protect network is doing awareness raising and campaigning on the deregulation agenda. Our most recent sign-on letter to Ursula von der Leyen was signed by more than 500 organizations from across Europe. So the network is growing fast. The EU's deregulation agenda, of course, officially is termed the simplification agenda. In our first open letter to von der Leyen, when we just got started, we pointed out that simplifying EU legislation is, of course, something that sounds very desirable. There's nothing wrong with that. We're not opposed to that. But deregulation and rolling back of rights and protections, that's extremely problematic. And we insisted from the beginning that the Commission's simplification agenda should include strong guarantees against any rollbacks of social, environmental, or human rights standards. And unfortunately, those guarantees were never made concrete. They never came forward. So then, in the first year of the deregulation era, in total, 10 different omnibus packages were presented by the European Commission. You've heard a lot, I think, in the last few days about the Digital Omnibus, but that was just 1 out of 10 that were presented last year. And I would say that almost all of them are deregulatory. They're not just about simplifying. They are about rolling back rights and protections in various fields. The 10 includes agriculture, defense, chemicals, corporate sustainability, automotive, food and feed, environment, and quite a few more. So we'll be hearing more about some of those in this session. And for us in the Rules to Protect network, it's very clear that we're now facing something quite unprecedented. It is the biggest deregulation exercise in the history of the EU. That has become very clear. These omnibus packages were produced at very high speed, 10 of them in just 1 year, and using all of them using more or less the same methodology that is quite flawed. They were produced in a very high-speed process, bypassing the normal lawmaking procedures that the Commission has developed, skipping public consultations generally, impact assessments as well, and with industry lobby groups enjoying really unprecedented levels of access and influence on quite a few of these omnibus packages. And those 10 that came last year are only the beginning. There are 3 more in the pipeline for this year. We don't know the content of those yet, of course. And the Commission's goal for the rest of this term until 2029 is to stress test all existing EU legislation. So all EU laws will be stress tested on their competitiveness impact before the end of this term. So it's an enormous exercise that is happening. In recent statements, the Commission refers to this as a deep regulatory house cleaning, which makes these rules and regulations sound as something dirty that has to be swept away. indicating a very negative view of rules, most of which have been developed to solve societal problems in the course of the last decades. So that is a very brief introduction to the situation as we see it now. And during this panel, we'll hear much more about the concrete impacts of the simplification or deregulation agenda, both in the digital field and also across different issues. And we will discuss what can be done to safeguard digital rights, social rights, environmental rights, other crucial rights in this context. And we'll hear examples, I hope, of what a different form of simplification could look like, a simplification in the public interest. So those are some of the key questions that we will address in this session. And now it's time to introduce you to our panelists, our three panelists sitting next to me. First, on the right here, we have Alina Smith, who represents the Equinox Racial Justice Initiative. On my left, Isabelle Schuurman, who represents the European Trade Union Confederation, the ETUC. And next to me here is Diana Vlad-Kalcic, who works at the European Commission at DG Connect. Welcome to all of you. We really appreciate all three of you agreeing to be on the panel here. And I should say, especially Diana, knowing that NGOs and trade unions have a different view, generally speaking, on simplification. But also knowing that you have cooperated very constructively and with a very open attitude with civil society for many years. We are really happy that you're willing to have this conversation with us. So welcome to all three of you. We're going to start with very short opening statements by our panelists. Then we'll have a discussion among the panelists. And in the second half, we'll have a Q&A, questions and answers from all of you in the audience and the answers from the panelists. So that's the plan. And I think we can get started with Alina. Why don't you start with your opening statement?
Thank you so much, Olivier. So, I mean, I guess I'm going to be zooming out a little bit as someone who has worked for a long time on the intersection of tech and migration questions, and then more recently on the intersection between technology and securitization. I guess I wanted to bring a perspective that situates the current deregulation agenda within a broader frame. And from the perspective of various communities, deregulation has been a kind of a norm for them, to the extent that many of the rights and protections that we're very concerned will be rolled back in the context of simplification, didn't apply to them, at least in practice, in any event. So the GDPR, for instance, has actually not been a brake on the EU's continuing efforts to crack down on migration and to expand surveillance of non-citizens, including its interoperability project that essentially runs roughshod over the most basic pillars of data protection. And the AI Act, as some of you might know, in the last moments of its negotiation, we know that member states succeeded in integrating carve-outs into that legislation so that some of its safeguards would not apply in the context of law enforcement and immigration enforcement. So in these different contexts, we have seen in our work that securitization, security, has consistently been brought as the justification for circumventing rights and for ultimately expanding the role of the coercive parts of the state. So, and I think it's one of the things that I'd like to bring as the broader context as well. The context of simplification or deregulation is happening in a context of Europe rearming, in a context of increasing securitization across Europe. And that this is not only a context we need to care about as a backdrop for this conversation, but also something to reflect on in terms of how technology and deregulation of technology is part of especially pushing forward that agenda. So just a few months before the announcement of the Digital Omnibus, we had the announcement of the Defense Omnibus, which of course foresees removing red tape within the context of the defense sector and boosting industrial capacity within that sector, and provides the framework or the ground for 800 billion euros of investment in defense for the next 4 years. And we know that digitalization and technology is a very important part of that. So for me, that the perspective to maybe set the scene from my side is kind of this bigger context to understand the role of technology in this, in not only a move towards deregulation, but a move towards militarism, a move towards securitization, and essentially a coming together of interests of business, defense, and technology.
Thanks a lot for providing that context. Isabel, you're next.
Good afternoon, and thank you for the invitations from the TUC, the European Trading Confederations. I'm very happy to discuss with you, which has started as a simplification schemes and that developed towards the deregulation agenda. This is not new. The simplifications element. Since the early 2000s, the European Commission has worked on what it has been called the better regulations, with an agenda, with a toolbox. I was myself part of a process, 2016-2019, in the Regulatory Scrutiny Board, the board looking at the quality control of the initiative tabled by the services of the Commission. And already at that time, there was a clear unbalance between how you would check impact assessment and evaluations towards economic impact versus of any other impact. The environmental one, the social one, the human rights one. And you could even see that in the numbers of pages dedicated to the way you could do econometrics to find out the figures, the numbers. Rather than to see the real impact of those measures on society. So there was a clear dimension, how will that cost to business versus what would be the price for civil society, for example, let alone a very short time period of time to look into, well, short-termism, to look into the impact on businesses versus the impact on society. We know that the impact of on businesses could be put in figures very quickly rather than the cost for societies over a longer period of time. I worked at ETUI, the European Trade Institute, back in time. I'm a lawyer by education, so I'm very much into regulation, and rightly so in particular. And I just would like to mention one very important article of the Treaty of the European Union, so the very foundations of what we are here and what we are doing here is the Article 3. And the Article 3 says that the aim of a highly competitive, this is the adjective, highly competitive social market economy, is to secure three things. The first one is social progress, the second one is full employment, and the third one is the protection of the environment. Okay, so that's the basis on which we should all work. And then questioning, indeed, the issue of simplifications for which we understand digitalization might be a tool, and we are well aware, and we are also playing that path and using that path ourselves. But then the shock that we got 1st of October of last year, when we understood, despite the fact that it was told, it's about simplification, it's not about deregulations. From the President of the European Commission, it has become, on the 1st of October, and I quote, "We all need simplifications, we all need deregulation." Well, that's two different things, okay? And then the second shock, as Olivier mentioned, will target the first one that was just adopted in 2024. The first omnibus attack the latest directive adopted at the European level dimension on, guess what? Human rights due diligence. So don't speak to me about human-centric simplifications, because it was human-centric deregulations. By the fact that within a very short period of time, not even a year, the Commission itself tabled a new text without an impact assessment or evaluation of adopted text a couple of, even 2 months before, not taking into considerations the democratic process of setting a legislations and adopting a legislation, and by which it was deregulations affecting directly workers in the supply chain, not having the possibility indeed to have access for us to the necessary informations, not even the necessary support, and all of that boiling down to employers not wanting to play by the rules and to have to deliver what? Data, to have to deliver informations on the way indeed the working conditions are organized in the supply chain. And we know how far it is, the better for businesses even saying, well, we have no clue about our supply chain, which in itself not reflecting the reality. Just to give you an example of the human-centric, and I will close with that before going into the next development. It is very strange, like a business, how far the supply chain is, has a quality control of any spare part of a product, let's say a car. Any spare part undergo a quality control to come back where it has to be assembled. And if this spare part is not respecting this quality control, there is something that is put aside, and the supplier will hear that it's not okay, will even not be paid. How come that we can have a quality control on a plastic piece, and we can't have a quality control on the way this plastic piece has been produced by workers? It's boiled down to avoiding, with the due diligence directive, to avoid the exploitation of workers as far as possible in the supply chain, because we know that the control is difficult, and we know that the business do not want to do that control because it's cheaper. It's labor exploitation at the end of the day. So for us, on the basis of this omnibus, we were we were shocked, but we have also very much reacted, and we were very happy. And this is my last point, that thanks to a claim to the ombudswoman in the European Union, the Commission was indeed alerted, not convicted because there is no kind of sanctions, but was alerted of maladministrations, abusing the issue of consultations, as Olivier mentioned, abusing situations by putting an emergency where there was no emergency, and of course, not complying with the rules, which should be indeed that the regulations or the rules of the directive has to preserve the general interest and not the interest of certain happy fews in the society.
Thanks, Isabel. Diana, your turn.
Thank you so much. And maybe I want to start with answering to your very kind introduction, because I do appreciate very much the invitation, and I appreciate the dialogue and the conversation, and at least for the parts that I am in charge of, which is the digital part of the simplification, and I coordinate this work across my department, but it means across the Commission, because we're working hand in hand with DG Justice as well, my colleagues in DG Justice. I think the dialogue with civil society has been present and is I think a stepping stone and really important element in our conversations. So I appreciate this discussion, and I think I've made the point yesterday, and apologies for those of you who have to hear me twice, but I think from the Commission's perspective, or on the digital aspects, we're in a moment where we are engaging with the co-legislator to develop and to lead to hopefully a sufficiently fast adoption of the rules that we've put on the table. And these rules are about urgency. And this is again something I explained yesterday, because I think if we were to speak about the same issues maybe 3 years ago or 5 years ago, we would not have that same conversation. I think 3 years ago I was working on the Digital Services Act, and of course, I mean that we keep the line very much on the enforcement of that, and that is our priority now. But the reality of the industry, and then the way that we're operating in a global world and not just in Europe is that the landscape has changed. And the competitiveness bet for Europe is very much different than a few years back. And so we are talking about a race to the top, I was saying yesterday, on the development of artificial intelligence. The way that I motivate my team, this was also something I was saying to the audience yesterday, and the way that I have gone into this job, because we are regulators, right? The fiber of the teams in DigiConnect is to write laws, not to reassess laws necessarily, is because the promise of competitiveness comes also with our ability to actually deliver on those objectives of Article 3 of the treaty in the medium to longer term, to deliver on our social model and to deliver on our values. And so the way that we have translated in preparing the Digital Omnibus, this some would call it dichotomy, but I think we call it a coherent objective, is that we do need to look with a sober view at our rules, how they function in practical terms, whether there are overlays or redundancies in the way that they're built, how they are applied in practical terms, and whether there is an optimization that we can make, but not to compromise on our values, not to compromise on those objectives. And this is still the sort of the guiding line that we have in the co-decision process now in engaging with the co-legislators. So whether we got it right everywhere, I mean, of course, the Commission's proposal is a documented proposal, but we did not go to the regulatory scrutiny board with this one, but we did document all of our evidence and extensive consultations in a staff working document that is available, so you can see how the process has gone here. And then I think another point, when you talk about deregulation, you will understand that I will not appreciate that word, as I don't think it's the mission that I was given. I was given a mission of simplification. And what do I see in this bag of simplification? I think there are several types of measures. The first one is maybe about cost optimization. And this is a business-centric type of analysis where we see, well, when you apply the laws, how much does it cost? What are your operations internally? What are the sort of the compliance costs? Are there redundancies? Is there duplication? How can we streamline this? And there's another aspect that we've done, for example, on provisions in the Data Act on data intermediary services. What was the effect on the market if you had to bear a number of obligations? And are those necessary? So there we're turning it the other way around and doing it as an incentive rather than as a punishment, if you will, a registration. But it's this cost optimization perspective. And the second element is one that is probably more delicate, but also extremely important. Because my starting point is to say, whenever we have European level regulation, normally this is simplification by design across the single market, right? You have one set of rules and not 27. So that's the perception, that is the intention there. But we also see in practicality that this promise is not always met. And it's to a certain extent normal because rules don't exist. I mean, there are humans and different institutions and different traditions as well who apply them. So sometimes you see fragmentation just by the way that the rules are applied in practice. So on several of these items, what we have done, and some of them are on the GDPR, which of course is the more delicate area of regulation, is that we're saying, well, we're going to base ourselves on case law, on European Data Protection Board guidance, on sources that come from the application of the law. And we're going to offer now to the co-legislator the opportunity, essentially, to tell both the companies and the enforcers what we meant by the rules. So to have, again, that harmonization element. And this is simplification for us. This is an understanding of simplification because it mitigates, from a business perspective, the regulatory risk that they're taking. And the urgency here, I think, in our understanding, in our analysis, comes from that race to the top on artificial intelligence in particular, where every day matters for a business. And the risk that they're taking in not getting investments, not getting those rounds of investments from venture capitals and others, those are ruinous for European businesses. Now, I'm asking you to make a mental effort, as our team have made in looking at the same objectives from a different lens. And this is, again, one of the tasks of simplification. We're looking at rules that are established and trying to understand how are they impacting competitiveness and how can we make them leaner, potentially, or how can we optimize them for that objective while preserving the values protections that they intended primarily to bring. This is, I think, the standard that we're trying to keep ourselves to account. And again, as I'm saying, the Commission's proposal is the Commission's proposal. We're making the argument because, of course, it's a solid starting point. But this is also why we want to engage in this conversation, to stress test it, if you will, as we go ahead and as we discuss with the enforcers. I don't mean to take too much time for the introduction, but there are maybe two other points that I really need to point to for what simplification means for us. And maybe counterintuitively, to a certain extent, simplification also means supporting enforcement. Again, on the digital rules, which I've worked on for the past 16 years in the European Commission, so I kind of witnessed the scale up of these rules. Businesses don't always say, or say, compared to other areas of regulation, they don't say the problem are the rules. The problem is the fragmentation in the application. So making that enforcement more coherent, better intertwined, and consistent, having the predictability by supporting also the enforcer, that's something that we are doing. And one example here is on cookies. On the issue of cookies, I mean, the first point there is that we're looking at how can we make this work in practice for consumers who today are just clicking through, ignoring essentially what they're accepting. I'm sorry, bear with me for the point of the caricature of the situation. But we also want to move it in the GDPR. We want to move these rules in the GDPR where they can benefit from the stronger enforcement there. So that's another optics. And I think yesterday I was talking also about the AI Omnibus, where we're really trying to consolidate some of the competencies to make sure that both on Artificial Intelligence and Digital Services Act, two of our key regulatory instruments, we actually deliver in optimal way on how we can enforce it. And then the last part is about experimentation, because we hear industry will say we're taking regulatory risks. And sometimes it's really not about changing the rules here. It's about framing the regulatory risks with the partnerships with the authorities as well. So sandboxing and these types of tools that ensure that in the longer term, of course, we allow businesses to experiment and then to produce products made in Europe, but then also that they are observant and then they respect our values. So I think maybe let me stop here. I have a couple of more points, but it's better to introduce them in the conversation. Thank you very much.
Perfect. Thanks so much. Great. So thanks for these excellent opening statements. There's a lot to discuss, I think. Now the panelists, you can react to each other, but I also have a couple of questions to start with for you. So Alina, maybe to start with you, can you say more about how securitization is not only a backdrop to the push for simplification, but is also driven by deregulation of digital technology?
Yes, sure. And maybe, again, just obviously we're speaking about policy files and portfolios, but I think it's helpful just to say something about maybe the political vision that's being pushed by these. Mm-hmm. And the political vision is one that seems to have a specific notion of human safety and prosperity. It's a specific notion of human safety that equates security really with investments in certain sectors, the security sector, and certain parts of the government that are and their coercive power, and notions around prosperity that essentially seem to equate what's good for industry as being good for the flourishing of Europe. So I think, we see this actually in the language of lobbyists themselves. So I think many of you are familiar with Digital Europe, which now has among its priorities defense and digital resilience. On its website, you'll read that Europe's security today depends on how fast we can turn digital innovation into credible defense capabilities. We have ASD Europe, which is the leading defense lobbyist in Europe, saying that the aerospace security and defense ecosystem is at the heart of the EU's security and prosperity. So this idea that bolstering industry is how we actually bolster our collective safety and how we actually bolster our collective economic well-being. And I think that's the political vision we need to really challenge at the outset. We see essentially an intertwining of securitization, tech, and business interests that is important to unpick. And I think even we see this in the fact that Vice President Verkunen is Vice President of Tech, Democracy, and Security. And within her purview is obviously the digital, but also internal security and borders, and actually the European Defence Union, bringing it to life in the words of her mission letter. So I think a lot of what we're seeing in this context is that the line between policymaking and lobbying is more blurred than ever. If we speak about, for example, the arms trade, so the European Network Against Arms Trade published a report back in 2023 that really gets into how the arms industry has been trying to foster closer ties with European policymakers. And indeed, it was in 2019 that under the first von der Leyen Commission, the DG for Defense Industry and Space was established. And one of the things that Thierry Breton did in the context of that was to establish a permanent dialogue between the European Commission and industry as part of a Commission expert group on defense, industry, and space. And similarly, the Defense Omnibus that was published last year was based on a strategic dialogue with defense industry and private sector companies. So I think what we see is that increasingly, and this is obviously, you all know better than I that this is equally the case in the digital space, that industry actors are increasingly positioning themselves as experts and even as partners. And actually, there's less and less of a sense, I think, that there's questions around conflict of interest, but more and more of a sense maybe among certain policymakers that there's a convergence of interests. And we need to actually speak to industry to actually define the problem and identify the solutions, which happen to be the solutions that industry is proposing. And this is, of course, equally the case in migration. As we're speaking of blurring of the lines, as long as we're speaking about securitization, the same is happening, for example, in the context of borders and policing. And many of these traditional security actors are regular attendees at Frontex Industry Days, alongside Microsoft, AWS, Unisys, and so on. So this brings us to the second piece, that the line between defense and tech is more blurred than ever. And so I was at Milipol in Paris last November, which is France's preeminent security fair. And one of the astonishing things is you'll see all the traditional paraphernalia that you would expect in such a setting, but the number of software companies represented in that space. So the EU and NATO are both very much driving towards a digitalization agenda, digitalization of defense, and this is very much represented in how tech companies are increasingly embedded in securitization. And of course, unsurprisingly, at Milipol, there weren't just defense companies, there was also Frontex. And there are also companies engaged in policing and supporting the work of law enforcement. And just maybe a final point that I think we all are very much inundated with the conversations around tech sovereignty as part of what we're trying to achieve through greater competitiveness and innovation. And it's just really important to understand the extent to which that is very much consistent and part of the discussion about strategic autonomy, and that those things are, in effect, almost indistinguishable. And if you look at the EU's strategic compass for security and defense, which was adopted in 2022, those things are both articulated as objectives. So investment in innovative tech, achieving competitive tech and industrial base, and tech sovereignty, all as elements of achieving overall strategic autonomy in the context of Europe's defense. So yeah, I think for me, again, it's really situating the conversation about what is the vision that is being advanced through these variety of different omnibus. Is it omnibuses, omnibi? Whatever it is, there's a broader political vision that we need to be cognizant of as we evaluate the stakes and as we evaluate our tactics to respond.
Thanks, Alina. Just to, I notice, I recognize the picture you portray of the Defense Omnibus and how that was prepared, because I think that was probably maybe the most extreme in terms of bias in who was invited into the process, and the furthest away from an open process of consulting stakeholders. The first omnibus on corporate sustainability was also quite bad, with handpicking certain companies and excluding civil society on a large scale, but also more progressive companies. But I think, and there were some DGs that might have had a better process, but I think this picture of a very biased preparatory process where the door was closed for important stakeholders is something we should definitely continue discussing. Isabel, I have a question for you about some of the topics that the trade unions have been very vocal about around the deregulation agenda. So you have been alarmed about the AI Omnibus aspects of that and the 28 regime. Would you like to elaborate a bit on why you're so concerned about these?
Yeah. Thank you for that. So I try to be short, which is not easy with the topic. Again, back to the basics. In the European Union, you don't have a principle of competitiveness. However, you have a principle which is the precautionary principle. That means that in the European Union, you cannot put a product on the market which is not safe for the citizens and, of course, not safe for the one using that product. And at the workplace, clearly, there is the obligations of the employers to provide a safe workplace. All of that just to say that, yes, you can simplify, but you have limits under which you cannot simplify. The second point is that why is the market, the internal market, so attractive for others? Because it functions well. And why it functions well? Because we have regulations. Because we are the one to set the limit under which you cannot do business in the internal market. Because you have to respect not only the people, the citizen, but you also have to respect the environment. All of that to come back to omnibuses, and that will be my last point on the omnibuses, because afterward I think we have to move forward, despite the fact that there are still some queuing. The AI Act, the GDPR, those two pieces of legislation are key to introduce a more than a transformative technology in society. It's a revolution in terms of technology. It's not me saying that. It's a range of Nobel Prizes. So if you want that this technology delivers for all, for you like for the business who are developing in the directions that serve everyone, and not just for the profit of getting access to your data to pile up the profits, and not delivering for you, because out of your data, not only your identity will be stolen, and is sometimes stolen, and you don't get the guarantee that with your data, not something against you can be done. Example, Croc, using your picture, yourself, your identity, to do something very illegal, very damaging for your reputation, for your own personality. So all of that is, the regulation is there to protect citizens, to protect workers, to protect employers, not to place and to use on instrument and product and services on the market that are illegal, not according to the rules that the European Union has. So back to the Digital Omnibus and the AI Act. The AI Act has recognized already back in time the workplace has a high-risk sector or situations. If you are already identified as a high risk, then there is particular measures to be taken. And why? Because it's a dimension of security. Okay. So my question, why the machinery directive is taken away? Why the safety component of machineries is reduced? It doesn't serve the protections for the workers. And bear with us. In another format where I'm discussing within a crowd of experts set by the Commission on a delegated act for how business have to report on corporate sustainability due diligence, which is human rights due diligence. I have to fight to have a standard on reporting which is not just the number of deaths at the workplace. Could you imagine that? So here, bear with us. Nothing against technology, nothing against using technology, and we'll give a second example by which we are on the path of simplifications using the technology and the digitalization. You cannot compromise on human being safety, in particular the workplace. And this is where it does not make sense in the AI Omnibus to look into that and to have table this part of reducing the definition of safety components, and of course having attempted to the machinery directive basic principle. The European Union is not there to take away protections. It should be there for social progress, and social progress is of course not at the price of workers' rights. On the contrary, and you have to do business according to the rules, and here for us no compromise whatsoever is acceptable. The second part I would like to mention is, of course, we were asked in terms of posting of worker. You know, when one company has a business, let's say in a member state A, and want to send workers in a member state B, because in that member state B, a machine could be broken and need to be repaired. For that, and it takes more than a certain period of time, you have, as a business, to have a notifications. You have to declare this posting. Okay. If this enterprise in member state are at different machines in different member states, might have to post workers in different member states every time a new declaration. We can understand that it could boil down to a burden. There is a reason why we post. There is a posting declarations, by the way. This, of course, to protect the workers. But okay, there might be too many declarations to do. So why not doing one declaration that would serve different kind of posting in member states in terms of not, I would not say 27, because I don't think that a business in member state I will have 26 posted workers in 26 member states. But let's take it, we reduce the number of posting to one because it's one declaration. We are on board. We were even, proposing that. But guess what happened when we were proposing that and discussing? Not only was the fact that simplification was welcome, and that was for us obvious, but then we were kind of requested to condense the informations to a point where those informations could not help any labor inspectorate, could not help any control, could not even identify the worker. So nothing that we could use in terms of posted workers when something happened at the workplace. And there are accidents at the workplace in such situations, like in the construction sector. So simplifications, yes, but compromise on the quality of the information that any national authority needs to have, it's a no. So to be in those kind of situations, it's important to be part of a simplification which should not be a deregulation, and I stick to that. It's not me saying that. It's Ursula von der Leyen on the 1st of October, so it's the Commission on board. We cannot, and back to the basic, there is a precautionary principle in the European Union, which is not, of course, somewhere you can find in the US. And we understand that we don't want, and it is not the model we have in the European Union, to put an unsafe product on the market. This is the reasons why we have those controls, to protect your kids, to protect yourself, not to have access to a product that is not in conformity to the rules of the internal market. And that leads to legal security and legal predictability for the business. It's fair competition at the end of the day for those business putting quality product and services on the market. So all the more important that, yes, we use digitalizations where possible, and the 28th regime is part of it, to be able to use a platform to do registrations for business, wanted to do business in the European Union. But here again, what we see coming back is what we see in the US is that you will have, the plan is to have the possibility to add a 28 regime, not me selling that, so much for simplifications, where you have already different system of business format or business form in the European Union, in Germany, in France, in Belgium, and that's normal. That's also where there is not a full competence by the commissions, and rightly so, to organize the way business can be done in certain member states. So to add another regime, that could be, a European regime, we do have it already. We have the European Society regime. And what we see in the European Society regime is that more than 60%, we are at the ETUI, in the form of a database. We have the only database that assess and monitor company law and how company law is developing in the European Union, in particular the European legislation. More than 60% of the SE, European Society, are empty shells. It's a business in itself. And why it is an empty shell? Because it's easy to do business everywhere. However, the European Society has not been created to circumvent the national system, national fiscal system, nor the national social security system, nor the labor protection of workers at the national level. So why creating on the top of the SC, where we have asked for closing the loops, and it's possible to do that, we've done that with other directives, why creating a new regime that on the top of potentially, and we have the evidence for that because it's not the first time that such a proposition is tabled, will create more letterbox company than anything else. In 48 hours, tell me who can check whatever in 48 hours. Can be dissolved as quickly as it has been created. So much for employee having special creditors statutes when in case of insolvency of businesses. All the more in terms of I have my place of registrations, which is the place where I will potentially doing regime shopping have less obligations, fiscal obligations. Let's speak about Ireland. I'll be located there, but I can send workers everywhere. On which basis? On the basis of the Irish legislation. You can imagine that workers will be here working in Belgium on the basis of an Irish legislation, which is very different from the Belgian one and very few rights in terms of social protection, but also in terms of workers' rights. Let's start with working time. So this is not something that we can accept. And here again, there is no full competence by the Commission to do so. And there is a reason why, here again, and that's my last point, on the 28th regime, there seems to be a willingness now to abuse regulation versus directives. Regulations is a piece of legislation that member states have just to copy-paste. They don't even have to think about things, just copy-paste in their national system. Whereby, by directive, those directives, and in particular for social rights, you set a minimum. And member states can always do more because there is a shared competency and not a full competence of the Commission. But member states cannot do less. So it's not by transposing a directive that you can reduce the level of protections at the national level. And this is something that has been also developed within the better regulations, which is a nonsense for me, which is not a principle, again, not a principle, it's the gold plating. So you can't do more. If you do more, it's gold plating. It gives these perceptions, it's luxury. Is it? Is it luxury to respect the very hardly won, very difficult won rights for workers in terms of your working time, in terms of your minimum wage that we had to defend in front of the court, and we succeeded to defend a minimum wage in the European Union. So all of that, bear with us. The European Union is not there to diminish your rights as a citizen for protections in terms of product safety and service safety, nor as workers in terms of your rights at the workplace, starting with the very basics right of health and safety. And if we speak about artificial intelligence, it's not just the machinery issue, it's the undue surveillance that is part of the algorithm that is used and bought by employers. They should know what the algorithm is providing. It's about the work pressure at the workplace. It's also about discrimination at the workplace, and in particular for women.
Thanks, Isabel. Thanks also for the examples on the posting of workers rules, which is, I think, a good example of how something can be done as simplification or as deregulation, when it's lowering standards rather than just simplifying. So Diana, I think rather than asking you a question, I will just let you respond, and maybe you have one or two other points you wanted to make, and then it's time for the Q&A.
Thank you so much. So I think, so I listen to you, I hear your points, and I think it's absolutely natural also that there's a debate around specific proposals and parts of our proposals. But I would not like us to leave this room and then to say the whole simplification agenda is an issue and everything that we're proposing is an issue. Because I do believe that we can see eye to eye on many of these things. And as I said before, I cannot stress enough, now the Commission's role is really to support the co-legislator in this, what we are doing. So I think I've heard you at the very beginning speaking about stress testing, but with a slight connotation of the risks of stress testing. And let me give you an example. So in the remit of my department, stress testing means all of the evaluations that we are conducting vertically, act by act, and then everything else that we do for simplification, and not only. One of the results of the stress testing exercise has been the report on the Digital Markets Act that was issued recently. And clearly the result of that report is we focus on enforcement. It is not a deregulation agenda for the Digital Markets Act, which is one of our strongest tools today for the digital market and certainly the platforms market in Europe, and all of the sides of that market, including consumers, other businesses, platform competitors, and so on and so forth. And I think it's important that you see this, that this is not a global deregulation agenda. There are points by points where we're having conversations about what's the right balance, but there are absolutely, I think, acts and principles that I would expect that people in this room and beyond consider as fundamental, which we're trying to reinforce with all of our actions. Then within the Digital Omnibus, I mean, you spoke about employment, and gives me the opportunity to point to a slightly peculiar type of proposal that we've made in the Digital Omnibus. So our legal services were thinking, we don't like the way that you wrote down a repeal of a regulation. That's one of the, it's not the first, but it's one of the first regulations that I ever worked on. It was a platform to business regulation, where we have a sort of a transparency framework for what online platforms, and I think in particular marketplaces and some search engines, need to do. But I sometimes speak about it as training wheels for us, and then of course with the co-legislator as well, on how we regulate the platforms space in Europe, because we've also learned during that negotiation that we were talking about two speeds or two sizes. Enter late Digital Services Act and Digital Markets Act that have a very different regime for the largest platforms. In the DMA, we call them gatekeepers. It's a bit broader than that. And for everybody else, because everybody else generally means those marketplaces in Europe that you buy. I think we have some examples. I won't quote companies, but you know them. If you live in this part of Europe, you go to certain platforms. If you live in Romania, where my family is from, they go to another one. And these are the only competitors to the gatekeepers, essentially, and then to other international platforms that are coming in Europe. And we've noticed that we're hyper-regulating them. We're over-regulating them with applications of rules. So we said, we're going to take away those horizontal ones, because the Digital Services Act does the job for everything else in terms of transparency and rights of users, including business users. And the Digital Markets Act does the job in terms of the gatekeepers and how we make sure that they are not the ones that take over the European market. But in doing this, in our analysis, we've noticed that we do have a special category of platform workers that are not protected to the same levels as other platform workers through the Platform Workers Directive that we're really trying now to push for a transposition in due time. And our observation was that we cannot diminish their rights. So this would be the independent workers on a platform that we're using today, the platform to business regulation, to complain, say, about the algorithms, price setting algorithms of a platform or something like this. And this is one example in the Digital Omnibus where I think that we've really catered for all of the interests and risks at stake in pushing the envelope further. Another example from my perspective is on cookies, and I've mentioned it before. I mean, I think that there it's really, really important that we do look, of course, from a business perspective, and that is one of the aspects, but certainly the rights of the user. And again, I don't want to repeat it, but we can look together at the architecture of that. And of course, businesses are not particularly happy with our proposal either, but there are fundamental elements, of course, there on how the internet really works and how it works for citizens as well. And maybe another example, so pushing on security, and of course, there's a slightly removed from the points that you were making, but another example in the Digital Omnibus is this platform through which we're saying, let's not centralize, but optimize and unify essentially the incident reporting in cybersecurity, incidents in data breaches, and a couple of other incidents. And this is presented as a simplification agenda, but let's look beyond that. So our calculations say if you're a business and you need to report under GDPR and IS2, DORA, and so on, then we're cutting 50% of your administrative costs by pulling one pipeline. Essentially, you report once on the incident, maybe you spend your time solving the incident, and then that information is being dispatched to all of the authorities that need to have it. But the other objectives here, which are not simplification objectives, are optimization of the actual reporting, because the reality of it is that people now report via private email, if they report at all. So underreporting is an issue, and cross-border underreporting is an even bigger issue. So for me, one of the objectives here is really optimizing that security objective, making sure that those authorities do get the information that they need and can act upon it through a tool that goes through the lens of simplification. So I felt like I had to bring these examples as well, and we can discuss them, because I don't want us to look at only at individual points that I understand we need to iron out and to discuss on how all of the rights and interests at stake are being managed. And maybe one more point on process, because omnibuses, and we've discussed omnibuses, these are tools, and they've been fast-track tools on a number of topics, but they're not our only tools. So again, in my department, we've made a proposal on telecoms, and where there are points of simplification through a revamping of the entire framework through the Digital Networks Act, having that coherent step in the regulation. But the other project that my team is starting is one that I am particularly excited about, also from a better regulation agenda and process. It's something that we call a digital fitness check. And that means very ample evaluation, not of one instrument, one by one, the way that we generally do it. And I think part of this optics of I'm looking at my instrument once and not so much at what's around it, generated lots of inconsistencies and issues that we need to iron out now. But with the fitness check, we're trying to look at the overlay, interplay, and I think effectiveness of the governance through which we are supervising these rules and seeing them come to life in practicality. So that's a better regulation tool. It might lead to further proposals, but this is not a decision that has been made, because there's a full process of analysis and consultation that has started and will continue, and engaging around these aspects and seeing, can we do better? Not necessarily can we do more, but can we do better what we are doing now? So maybe I leave it at that.
Okay, thanks a lot also for those examples. So now it's time to open it up to the audience. And you can ask questions, you can make comments to our panelists, and let's take first 3 questions and comments here, and then at the very back.
I'm going to use the privilege of working for EDRI. Itzaso Dominguez, European Digital Rights. Thanks so much for the panel, and thanks so much to Ella, who was behind all of this, and thanks so much for being here. I really appreciate that. Also you, Diana, I know it's not easy, but something that I think it's interesting, because I'm going to focus on the Digital Omnibus, because there's so much I can cover with my small brain. Because you mentioned signals, even so, one of the few things that we like about signals, and that are actually speaking about simplification and rights, will be these privacy automated signals. I won't bore you with that, but this is true. And you know how much we appreciate that, but you also know that the rest of the proposal is not particularly to the liking of civil society. But also, I think when it comes to companies, something that we have realized, and we have heard that from lawyers in companies and from DPOs, is the legal certainty perspective, right? Because you mentioned, Isabel, companies also need legal certainty. Exactly. And if there's actors that are much comfortable with legal uncertainty and that are able to navigate, those are the companies that have 1,000 lawyers. And I'm not going to say that those are even foreign companies. There's EU companies that also have that capacity to navigate the legal uncertainty. And this legal uncertainty, I'm not sure it's going to go away with the negotiations, right? We are speaking about deregulation when it comes to fundamental rights, but also about legal uncertainty, and both of those are harmful. So I would like you to address that, right? Because I think, one of the promises is competitiveness, is innovation. And the other thing, if I may, is because you mentioned that companies go to the Commission and say, we cannot innovate, right? And which we are also being told, because I speak with companies. But those companies that are telling me that is the companies that are actually dying to use some kind of privacy-enhancing technologies in order not to apply GDPR. They don't want to apply GDPR. GDPR is something that allows companies to collect and process data, or if privacy allows them to access the device and the terminal if there's consent. So, but the thing is that many of these companies, and when it comes to European companies, because there's not this level playing field that you're speaking about, they feel that this race to the bottom is the only thing that they can invest in. I always see these two rats fighting for a crumb, and the crumb is going to go to the biggest companies. How are we managing this idea that the companies that are telling you that are the ones that do not want to respect the law? And when it comes to not respecting the law, that means not respecting and violating fundamental rights. Because I think this is something that we need to consider, right? The companies that are begging for that, I'm not sure they are doing that because they want to strengthen the trust of the people and that they want to respect fundamental rights. It's just that they have found out that the only way for them to be competitive is this race to the bottom. Sorry, thanks so much.
Thanks a lot. There's one more question or comment in the back, and then it's already time for our closing statements. Maybe we can have one more.
Thank you very much for all the information. I learned a lot. I'm Sohail Human, Director of the Sustainable Computing Lab, Vienna University of Economics and Business, and editor of ADBC, the only existing specification that can implement 88B currently. I actually have comment about this, but we are not here to hear me, only if there is time, maybe at the end. We are here to hear you, and my question is, human-centric simplification, a contradiction in term? Can you just answer this in a few sentences and very to the point? So what is your position about this? Thank you.
Thank you. And one last question or comments, and then we go to the panelists.
Hi, my name is Kaveh Nouri. I come from the European Disability Forum, and I have a question, maybe mostly directed to Diana, but if anyone else also wants to say something, I'm happy to hear your reasoning. I feel that on the one hand, we want to be able to mitigate bias because it's important that AI is accurate. But on the other hand, I also feel that the ways that the Omnibus, for example, makes it easier to use sensitive personal data to find and address bias, especially when you also take into context that some of the enforcement mechanisms are also weakened. And I know we might have a difference of opinion here, but my take is that it is a weakening when equality bodies are not able to go directly and ask for documentation. That's just an example of what I consider a weakening of enforcement. Then I also feel that there is more. Even if it looks good on paper, I feel like I cannot trust the legal frameworks as much, and I feel that we need to give more thought to how user trust also in the frameworks affects things. Because, for example, I have ADHD, and I actually use LLMs to help me organize my work, like to prioritize and give me suggestions. But sometimes I also am open with it about my most like what I have difficulties with, because then it can adapt it. But I feel less comfortable doing so when it's a cloud-based processing, and it's like also how it is in the US. But if we change our rules here, I would also be even more. So in my own case, I bought a gaming laptop which can run local LLMs, but I don't think it's viable for everyone. So if we really want to make like everyone who can be helped by AI tools, we must create trust. And I'm also that's why I'm wondering, like, aren't we deregulating too much in the sense that it actually comes at the expense of user cost? Because I know there is many in the disability community who are also worried about their privacy, but they also we have a lot to gain from positive uses of AI.
Okay, thanks a lot. So then it's time for closing rounds. So each of the panelists have, unfortunately, only 2 minutes to respond. Time flies. And let's start with Diana, so some questions directly to you.
Sure, thank you so much. I mean, the point on legal certainty, from our perspective, at least for the Digital Omnibus, and I cannot speak about all of the techniques and ideas of my colleagues on the other omnibuses, but this has been the focus point. And as I say that we're supporting the co-legislators because we are, of course, discussing exactly this. Does the text bring that legal certainty? I mean, if it's a matter of process, I think this is also another reflection of what happens with legal certainty when a text is under discussion, and this is part of the time pressure as well on omnibuses to make sure that that information reaches both industry, but certainly the regulators and everybody else in time. So there's we minimize that opening. But legal certainty means also clear legal text, and means explicit legal text. So some of our regulations, and I don't mean only the GDPR, are principles based and all for the right reasons. But then there's a question mark of how do we accompany those principles into a translation that becomes predictable for everyone. And part of what we have tried to do with some of the proposals, and maybe I go to your point here, is that our intention in addressing those elements of how to use special categories of personal data through AI, both the proposals in the AI Omnibus and the ones in the GDPR, are intended to frame in a more explicit way what happens in practice and have those backstops there. So again, yesterday we were talking about the GDPR proposal where we say we do have essentially, in my non-lawyer terms, a due process that a controller needs to follow if they're using inherently, so without wanting to, special categories of personal data. But the bottom line is, thou shall never make it, so speak about it, and never make it public. No, so those protections remain into law, and this was our intention in putting on the table text that then becomes clearer of what happens, whether the processing happens in a cloud, on a machine, or anywhere else. And then I think I try to keep it short. Of course. I wrote down a question I'm no longer understanding. Apologies for this. So, of course, there was the question on those companies who are not respecting the law or asking us to do something else. It's not the reading that I have from the ample spectrum of stakeholders that we've discussed with. I can see where you're coming from, because sometimes, of course, industry will ask you to change the law in a way that is convenient for them. But part of our conversations have also been with very small companies who say we need this level of legal certainty in what we are doing. So I think it's more nuanced than that. But I do understand what you mean by essentially the deregulation claims that will inherently come from parts of the spectrum. And then the last question that I will address, maybe it was answer to the question of the panel, human-centric simplification. Is it a contradiction in terms? And I think for me, it's absolutely not. Does not have to be a contradiction in terms. And the mandate that we have is to preserve those values in the best possible way.
Thank you, Diana. Alina?
Thank you. So I suppose the thing is that Diana mentioned this a bit earlier, it's very easy to come at these questions from our little compartmentalized approach. And there's a sense in which, as we've already heard, there are ways we can imagine that we can simplify our existing legislation in beneficial ways societally, right? But of course, the reason there are scare quotes around simplification is that it's not clear to all of us in the room that that's the agenda. And I think what I've been trying to raise is the question around who is actually setting the agenda and towards what vision. And I think even if we can see, wins or advantage in specific contexts and specific examples, it's not to deny that there are benefits there. But as a bigger picture, which humans, which people, which entities are setting the agenda and to which end? And I started by talking about our existing legislation. Like the GDPR is a very powerful regulation that has never been applied equally already because of notions of how we need to actually, we would tie the hands of governments in keeping us safe if we were to actually apply it equally, right? This notion of security that actually leads to circumvention of fundamental rights. So we already have gaps in trust with our existing frameworks, which on paper are robust. And so I think that's the core question for us is how can we trust that the agenda is being set by those with the interests of our broader flourishing and well-being. And so I think that for me, we need to step out of our compartments and we need to understand that this is a digital rights issue. There's the Digital Omnibus, there's a retrenchment of digital rights, but this goes far beyond, it's bigger than digital rights, and we can't approach it as only a digital rights issue. And we actually have to take our cues from communities that have been living in a context of normalized, actually, deregulation in terms of what the stakes are, in terms of what our tactics are. We need to pay attention to these questions around access to power, access to policymakers in defining the problem and defining the solution, and who are the beneficiaries of that, and who is perceived as the expert. And our notions of safety, how much are they entrenching the power, again, of industry, but also the coercive power of the state? We need to turn that around and challenge this notion that that's what safety entails. So I guess that's my very short answer to your question.
Thanks a lot. Isabel, you got the last 2 minutes.
Oops, yeah, thank you. I was reflecting on those conclusions, and I think they are indeed very wise. So it boils down to how do we effectively exercise democracy? And the rules, the regulations of our society is part of this balance of power. So to hear every time we have over-regulated, it's too much of a burden, it isn't. It is far from being a burden. It's the way our society can work together, balancing those interests on the basis of a rule of the game that are very clear. Not if you don't respect the rule of the game, which are partly something that, and I just want to bring it with you because I think it's telling, what the certain employers start doing is by transposing a directive, saying, hey, we don't agree. Could we change the directive by the transposition? And by doing that, wanted to change their obligations here, back to reporting obligations on, guess what? Pay transparency. Pay transparency. This, since 1975, fundamental rights of equal pay for equal work or work of equal value. We have still employers saying, no, we don't agree. So what we've been doing is we've put the price, because it's too costly, said the employer. So we put the price for the women per year who will not get paid equally. And what will be the price when they will retire? Because the basis of their pension will be exactly what they have earned during their professional life. So put the price on what is a burden, or whether it is a burden, please question, and who will carry that? It's not the business. We've put the price on how much cost a software to organize in the businesses the setting the pay transparency issues. Of course, you have, in terms of is there an issue, you have to act, and this is also the problem. So here, the rule of law is here to be respected by every actors in society. And it's not acceptable that For example, certain businesses says, we don't want, and it's exactly what we heard back in time, with the Omnibus number 1. Business saying to the Commission, you can do whatever you want. I will not report on violation of human rights in the supply chain. How come that we still accept those economic actors in the internal market? How strong the Commission has to be and the European Parliament not to give in to those. And I think this is our responsibility at the end of the day, back to digitalizations, not to call the driver to bring us food, because we know that behind that, despite the Platform Work Directive, those workers are still not protected. Most of them are not workers as they should be. They are bogus self-employed. They bear all the risks that business should carry, because those platforms do not want to be identified as employers. And guess what? Because they do not want to pay social security contributions. So who are losing out of that? Not only the workers, but society as a whole. How do you want to finance the pensions if the employers do not pay their fair share to the society? So yes, the rules are there. This is not about over-regulations, far from that. And bear with us that the regulations is, of course, evolving along the years and the development. So this is the reasons why the ETUC is very much on board that those technical innovations like artificial intelligence should deliver for all, and not just for the one wanted to make profit on the back of the citizen, on the back of workers by stealing their identity. And of course here, not just their identity, but at the end of the day, it's your dignity that is stolen. And I think here again, back to women, the one who are facing the discriminations and the attack, even at the workplace via digitalizations, are the women and the migrants. So bear with us, we need to protect those workers so that not only the workers in Europe, but also the click worker that are very far. And imagine the situation of a click worker to clean what you should not see on your Insta. Who is protecting that workers against the violence that this person has to see more than 8 hours a day, by the way, without a rest period, without having holidays, not having a kind of counseling after having seen all that violence and pornography? So this is what platforms are up. And this is not something that we should allow, not should we allow to pay a platform to deliver you food on the basis of labor exploitations. So check, please, first the platform you're using before asking for that. And the ETUC is really asking for a directive on AI at the workplace, because we know that there is a very added value for us workers to use AI at the workplace. It simplifies also some of the tasks. But then we have to be part of the governance of checking these AI tools and checking the monitoring of it and checking how, if there is damages for workers, we can remedy those damages, like undue surveillance, like discriminations, because it's not in line with, here again, the human rights dimension. And human rights are not a compromise. This is part of the democratic system we are in. And I think this is something that I will very want to give to you back as takeaways, is that we all have responsibility in this society to use technologies, but to be well aware that without any regulation and without protections against the one out there, and there are some, who want to abuse that technology, in particular to access your data and to the profit out of it, not to let them access your data, that's one thing. And as a worker, to be well aware that, of course, you have a right to say no, you have a right to disconnect. You have also a right to use safe tools, machines, products, services at your workplace, and you are not a guinea pig. So we are not here, in the European Union, to be the tester of products that are not safe. And this is one of the unique regions in the world where you have still these protections. So don't give in to the big giant and GAFAM of those just wanting to sell you something which is not mature enough. needs to be tested, but not on humans, please. And the human in control is one of the principles that the ETUC is requesting. It's not the machine that has to monitor us. It's us that have to monitor the machines, and we can't let the machine control ourselves. So bear with us. It's not over-regulation, far from that. It's paving the way for a safe and sustainable innovations in the workplaces, and by the way, also in society.
Thanks, Isabel, thanks. So with that powerful statement, we have reached the end of this session. So I want to thank our panelists very much for your excellent contributions, also the audience for participating and for the questions and comments that you had. Yeah, thanks for participating and have a great afternoon. Thank you.